Navigate the complex world of contract law with precision. This session dissects critical clauses, offering insights vital for legal professionals, business leaders, and negotiators alike. Welcome to a simulated negotiation, a crucial training ground for understanding contractual risk. We observe TechNova Limited and GreenFields plc as they negotiate a multi-million-pound AI server contract. This scenario highlights key legal principles in action. Harvey, TechNova's lawyer, we propose this clause: TechNova shall not be liable for any loss of profit, business, or indirect or consequential loss arising from the use of the servers. This is a classic exclusion clause, designed to absolve a party from specific liabilities. For businesses, understanding its scope is paramount. For lawyers, drafting it precisely is an art. It directly impacts risk allocation. Case law parallel. In Lestrange v. Graucob, 1934, the court held that a signed contract with an exclusion clause is binding, even if the party didn't read it. This underscores the importance of thorough contract review. Rachel, GreenFields lawyer, we can accept some risk, but we need a cap. How about, TechNova's liability for any claim shall not exceed £100,000. This is a limitation clause, which restricts the maximum financial exposure for a party. It doesn't eliminate liability but sets a quantifiable ceiling, crucial for financial planning and risk management. Harvey will also add, TechNova shall not be liable for any breach of this agreement, howsoever caused. This true exclusion clause attempts to negate liability for any breach. Courts scrutinize such broad clauses rigorously, especially if they seek to exclude liability for fundamental contractual obligations. Rachel, we need certainty. Add, any claim must be notified to TechNova within 6 months of delivery, failing which all liability is excluded. A time-limiting clause establishes a strict deadline for claims. This provides commercial certainty but requires diligent contract management to ensure compliance and protect rights. Donna, paralegal, ensure all these clauses are in the main contract and both parties sign. Relying on separate documents or receipts can lead to enforceability challenges. Incorporation ensures a clause becomes a legally binding part of the contract. This can be by signature, reasonable notice, or consistent course of dealing, demanding careful procedural adherence. Lewis, GreenFields lawyer, this clause is ambiguous. Does loss include loss of data? If it's unclear, the court will interpret it against TechNova. The Contra Proferentem rule dictates that ambiguous clauses are interpreted against the parties seeking to rely on them. Clear, unambiguous drafting is therefore critical for enforceability. Harvey, even if we get these clauses in, they must pass the reasonableness test under the Unfair Contract Terms Act 1977. The Unfair Contract Terms Act 1977, UCTA, mandates that certain exclusion and limitation clauses must be reasonable to be enforceable. This statutory safeguard protects against oppressive terms, particularly where bargaining power is unequal. Case law parallel. In George Mitchell v. Finney Lockseeds, 1983, a limitation clause was deemed unreasonable due to prior settlement practices. This highlights the objective assessment courts apply. Rachel, will sign, but only if you confirm in writing that the exclusion and limitation clauses have been explained and are fair. Harvey, deal. But remember, ambiguity or hidden clauses can lead to judicial invalidation. The contract is signed, but its true strength lies in the enforceability of these clauses. For effective contract review and negotiation, always ensure clauses are clearly incorporated, unambiguous, and reasonable under UCTA. This case study underscores the complexities of exclusion and limitation clauses. To enhance your negotiation skills, refine your contract drafting, or prepare for legal challenges, thoroughly analyze these principles. Review your existing contracts, identify potential vulnerabilities, and seek expert legal advice to fortify your agreements.